All right. There's a fair amount that I agree with Professor Fisher on, but it's much more interesting if I focus on things I don't. So, setting aside perhaps his being a little too confident about the originalist footing of Apprendi and Crawford itself, I'm going to make three basic points. The first one is originalism is a pretty good idea where the soil supports it, but a lot of these issues, particularly these newer ones that the court is getting into, are more of a soft ground or even a quagmire. And so you're trying to build too much of an edifice upon quicksand. It's going to sink. The second theme I'll make is that you have to be careful of what you wish for, that a lot of liberals want to go rah-rah for certain originalist little pieces, but they wouldn't like the whole package that it would take to make it consistent. Justice Thomas is willing to give us that whole package, but that whole package does not look, on balance, more favorable to defendants in some ways than the little pieces that some litigants have understandably picked out. And then the final one is, at the very end of his presentation, Professor Fisher rightly touches on the idea of some bright line rules, but actually there are a fair number of areas where if you follow originalism, you'll move away from bright line rules. And Justice Scalia likes originalism, he likes formalism, but there are some places where you really have to pick between the two. And so sometimes it'll lead us away from things like the exclusionary rule that others would have embraced because oh, it's relatively simple, it's clear, it tells police exactly what to do. All right, so the first point, let's start by talking about these points in the context of the jury trial and sentencing cases. In terms of whether the ground here is soft enough to be a quagmire, I'd say the text doesn't define what's a trial or a criminal prosecution. Did it include sentencing? Well, there was no sentencing phase in the 18th century. There was some evidence that juries knew of the punishments, more so in England than in America, but certainly there's some evidence out there. But nothing like what the modern sentencing proceeding looks like. And Professor Fisher concedes, certainly by the time we get to sentencing guidelines and all of the hot issues in litigation today, we don't have a lot to build on there. In terms of being careful what you wish for in this area, well, let's take a look at what this jury trial would have looked like if we were giving the jury the power to sentence openly. We'd also be abolishing peremptory challenges. We'd be abolishing voir dire. We'd run criminal cases in an hour or half an hour. I don't think there are a lot of defense lawyers who'd like that. In terms of, oh, we want rules to constrain judges, well, we'd be getting rid of jury instructions where the judges define mens rea for the jury. Jury would just decide, are you bad, are you wicked, right? That's not a very pro-defendant kind of ruling. You know, I might be comfortable with it, but I think a lot of the newfound friends of originalism might not be. Would we be abolishing or constricting the rules of evidence? Let in past criminal records. Back then you could tell someone had a felony. He was branded on the thumb or something like that. So the jury knew this was a bad guy. We don't need to cut him leniency this time. These days, we don't let any of that in. And so again, if you're going to trust the jury one way, you ought to trust the jury the other way. But I think people want to kind of have the part of the cake, the icing that's good for the defendants and not maybe the other parts that cut against them. And likewise, knowing the punishment, simplifying jury instructions would conversely give judges a lot more free hand to voice their own views. Professor Fisher says, well, one of the themes here is curbing the power of judges. Back in the 18th century, judges had tons of power to comment on the evidence, to make their views known, to lean on juries, short of throwing them in prison. But they could really lean hard and tell them, you know, the evidence here, there's only one way you can read it. And the jury could do what it wanted with it, but they weren't so timid. There wasn't the risk of reversal on appeal or habeas. Sentences were carried out right away. So judges had more authority in a lot of ways then. Finally, if we were going to do the originalism, we'd have to do much more. We'd have to follow Justice Thomas's opinions. He's the most consistent to his logical conclusion. We'd be abolishing the exclusionary rules. Right? So not formalism, it'd be originalism there. And we'd be abolishing plea bargaining. we'd have 20 times more trials. Enormous practical problem. But no one except Justice Thomas on the court is willing to go that far. It's not even clear he would go that far. And so you have this odd situation where on the court you have one or two committed originalists. And then you have several other justices who are fair weather originalists. They're really motivated by an individual fairness interpretation that is more at home in the due process clause, frankly. So you get these bizarre things where the court won't follow a principle consistently. It'll only go so far, and not far enough to prevent circumvention in plea bargaining, etc. So the Supreme Court strikes down, it finds a way to uphold the federal sentencing guidelines in Booker, because Justice Breyer is wedded to them, having been the architect, and manages to woo Justice Ginsburg back over by saying, oh, they're fair enough. But strikes down state sentencing guidelines that are widely recognized as being fairer to defendants, less constricting, doing less in the way of giving judges power to augment sentences with relevant conduct and the like. So when you don't have a consistent coalition of 5 originalists on the Supreme Court, you're going to get a hash out of the court if it tries to pick and choose and dip in, because the other justices won't put together a coherent package that would have made sense and would prevent circumvention. All right? Now, on to how those ideas I talked about apply in the Confrontation Clause area. I agree with Professor Fisher. It's a good thing that when you have a clear central case that the provision was designed to deal with, you should deal with it today too, clearly. And that's true of the equivalent of the Walter Raleigh trials, where the government is trying to railroad a defendant, especially a political defendant, and trying to circumvent proof in open court. It shouldn't be able to hide behind it. Now, behind depositions or worse than depositions, sorry, just ex parte interviews by officials of the state. Even there's a little bit of historical room to question. The Marion Justice of the Peace provisions did allow justices of the peace to do some examinations in America in the 18th century before trial went ahead, and those statements could be used. But let's set aside that quibble, all right? So we agree. The government should not be able to get around bringing in a witness it can bring into trial. But let's talk about some other situations. How about 911 calls? Did those exist in the framing era? No, right? We can extrapolate some general ideas about 911 calls, but you're kind of having to make it up with, at best, some general guidance or themes. There's not a bright line rule that comes out here. How about these questioning of a rape victim gently by a battered woman's advocate or something like that? Is that the same kind of thing that the framers are trying to get at? Not really. You might be able to extend some of those principles a little bit, but you have to be very cautious because it's not the same set of considerations that the framers were even dealing with. It's also worth noting that the rules of evidence and the way that the courts approached confrontation was hugely in flux in the 18th century. And so it's fair to say that Professor Fisher's approach, which he's persuaded the court, and I admire him for doing, persuaded the court Melendez-Diaz to adopt, freezes in place a snapshot of a law that was not really codified, that was in flux in the late 18th century. So, for example, there were no lab examiners, right? Now, with the lab examiner cases, I have a little bit of sympathy for Professor Fisher's position, because there, we actually do have some scandals in America of labs taking, not failing to test things, and then it turns out it's powdered sheetrock rather than cocaine. There have been some scandals, and also it's usually possible to rerun many of these tests. But those are functionalist arguments that confirm for us that the formalist or originalist reading is not ridiculous or disastrous, right? So formalism and functionalism, originalism and modernism kind of work together there. But let's take a different example. Let's take coroner inquests, all right? In a drug case, you're usually doing the exam and calling the drug tester within a year after the drug test has been done. But murders have no statutes of limitations, right? So, and the murderer may be on the lam, may run away, and may be tried 10 or 20 years later. Well, the autopsy was done long ago. Coroner may be dead, long gone. Even if the coroner's around, what's the coroner going to do? Does the coroner have an independent memory of what the 1 out of 1,000 autopsies he did 15 or 20 years ago? No. He just reads it, and under that fiction of recollection or flesh, he says, yes, in fact, this is what, I found this above the spleen, and so on and so forth. So there's not great history that says we have to reach this result based on the 18th century, and there are very substantial policy and common sense reasons not to. Indeed, there are good reasons to think the framers would not have pushed it that far. It's just that they articulated a slogan without fleshing out its outer limits. And so I think we need to be very careful, particularly about what Professor Fisher says about turning it into a bright line rule where it's not been so clear. So the final thing is that I think if you focus on originalism, sometimes you look at this only as a minimum. As Professor Fisher said, this is just about a few things that are in there, and it's not about a whole bunch of other things we can trust the rules of criminal procedure to update. And in fact, if you want to look seriously at what it takes to confront complicated scientific and forensic evidence, note the word is not cross-examine, it's confront. So that would imply it should include more things. What does it take to produce an effective cross-examination? Support for, forensic experts and other things like that. But an originalist focus might distract from serving those originalist values in more modern ways. And so I guess my bottom line is 2 cheers, not 3 for originalism. I think it works pretty well in those core cases like the Sir Walter Raleigh cases, but I think a lot of what's being litigated today are not those core cases, as Professor Fisher effectively concedes, and I think there are real dangers in taking what was an evolving rule and freezing it into a slogan that can be both over and under inclusive.